distinction drawn between United States citizens and non-citizens in the context of the Fourth Amendment of the United States Constitution. The Supreme Court has held that the Fourth Amendment does not operate to protect all citizens, regardless of their connections to American society. So the 9/11 hijackers are not in the same status as individuals in this country who are citizens of the United States. Rather, the Fourth Amendment operates only to protect the class of persons who are part of a national community or who have otherwise developed sufficient connection with this country to be considered part of that community. The farther that an individual is removed from such community, then the weaker the claim he has to constitutional protection. I agree with the gentleman that rewriting the authorization for use of military force and extending this protection, particularly as it pertains to United States citizens, greater should be done, but what the gentleman wants to do does not have the kind of strong bipartisan support that's necessary to pass the House. This amendment does, and I urge my colleagues to support it and reserve the balance of my time.
Gentleman from Washington.
Mr. Chairman, I yield 2 minutes to the gentleman from New York, Mr. Nadler.
Gentleman from New York is recognized for 2 minutes.
Thank you, Mr. Speaker. I rise in opposition to this amendment, but Mr. Goodlatte and Chairman Smith and I are in agreement, I think, on the goal, though I think the three of us mutually disagree on elements of this amendment. The amendment, while intended to enhance protection from U.S. citizens, in fact does the opposite. Right now, Americans on U.S. soil cannot be detained indefinitely without charge or trial. Rather than affirming this fundamental principle, the amendment implicitly authorizes the military to detain Americans on U.S. soil indefinitely by premising its protection on the mistaken assertion that the AUMF, the Authorization for the Use of Military Force, allows such detention, which I disagree with Chairman Smith, it does not. No such authority exists. The AUMF does not grant this authority, and we should do nothing to suggest otherwise. In fact, we should be taking clear and immediate steps to ban indefinite military detention altogether, and the Smith-Gibson Amendment, which I support, takes a good first step in doing this by prohibiting the detention without charge of any person arrested or detained in the United States. We should also pass my No Detention Without Charge Act, which would cure the problem altogether by preventing indefinite detention without charge or trial for all persons in U.S. custody, at home or overseas. Secondly, this amendment would create greater uncertainty in habeas corpus cases and raises significant constitutional concerns. The amendment seeks to raise the burden on the U.S. government to prove that a U.S. citizen is an unprivileged enemy belligerent, but that is not the same as requiring proof that the person is being lawfully detained, which is what habeas corpus is designed to do. The creation of a two-tiered habeas system with one set of standards for U.S. citizens and a different lesser standards for non-citizens raises very troubling constitutional concerns. Our Constitution simply does not permit us to permit greater basic due process rights based solely on citizenship. And although the Chairman, Mr. Goodlatte, is right in citing the case that he cited, he talked about connection with the United States. Someone who is in the United States, physically in the United States, and is arrested there, has the same constitutional Fourth Amendment protections as an American citizen. Any changes to habeas protection should be studied carefully through regular order, not through rushed attachments to the Defense Authorization Act. Passing this amendment would be a serious and dangerous mistake. I urge my colleagues to vote against it, and I yield back.
From Virginia?
Ask how much time each side has remaining.
Gentleman from Virginia has 1 minute remaining. Gentleman from Washington has 1 minute remaining.
Mr. Chairman, I yield myself the balance of my time to say to the gentleman from New York, you cause the members of the Congress to have a Hobbesian choice of having to choose to give the protection to every single person in the United States, including the 9/11 hijackers and others, or you have the opportunity to choose to give it clearly to United States citizens who are clearly entitled to have it. You do not have the ability, with your amendments, to draw that line between those who are lawfully present in the United States and would be entitled and those who do not. And as a result of that, I would urge my colleagues to oppose the amendment that the gentleman describes and support this amendment, which will advance the cause of giving United States citizens greater protections, reversing the burden of proof, putting that burden on the government, which is, after all, the American way. It is, after all, what the Bill of Rights provides. You have to show that in order to convict a United States citizen in our courts, or certainly in a Article III court, and it should be in these military tribunals, the burden of proof on the government to prove that and do it by a higher standard than they have to under the law that exists right now in the AUMF, which is only reasonable proof, not clear and convincing, as this amendment requires. I urge my colleagues to support this amendment as the best way to move forward in protecting the rights of American citizens.
Gentleman from Washington.
I yield the balance of my time to the gentleman from New Jersey, Mr. Andrews.
Gentleman from New Jersey is recognized for 1 minute.
I ask unanimous consent to revise and extend my
Without
remarks.
objection.
Thank you, Mr. Speaker. I share with the author of this amendment the goal of clarifying and strengthening the time-honored writ of habeas corpus for all American citizens. But my concern is that sometimes by omission we limit people's rights. This amendment is very carefully but narrowly drawn in such a way it begs questions about the exclusion of those outside the ambit of this amendment and their rights. The gentleman, I know in good faith, is trying to promulgate an amendment that broadens the right of the writ of habeas corpus. But I think when compared with the Smith-Gibson language that this modifies, that it raises by omission an intention of the Congress to narrow the right of habeas corpus. So although it is not the gentleman's intent, I believe is the effect of this amendment. And those who believe that the right of habeas should be strengthened and broadened, I believe should oppose this amendment and support the underlying language, which I in fact do. I yield back.
The question occurs on the amendment offered by the gentleman from Virginia. All those in favor say aye. All those opposed, no. Opinion of the Chair, the ayes have it. Gentleman.
On that, I request a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Washington will be postponed. Who is it? Okay. It is now in order to consider Amendment Number 12, printed in Part B of House Report 113-108. For what purpose does the gentleman from Florida seek recognition? Clerk will designate the amendment.
Amendment number 12, printed in Part B of House Report number 113-108, offered by Mr. Radel of Florida.
Pursuant to House Resolution 260, the gentleman from Florida, Mr. Radel, and the member opposed each will control 5 minutes. The Chair recognizes the gentleman from Florida.
Thank you, Mr. Chairman. For too long, and at the hands of really both parties, the White House has been operating with secret memos and behind closed doors hidden from you. And this is why we are offering this amendment requiring the Department of Defense to submit an annual report to Congress which basically goes over who, why, and what. Who? The names of any U.S. citizen subject to military detention. Why? The legal justification for their detention. What? The steps the executive branch is taking to either provide them some sort of judicial process or the path of possible release. Now, this amendment requires that an unclassified version of the report be made available to every member of Congress. This amendment shines light where there has been darkness in this country, ensuring freedom, liberty, and justice for all. While there is a legitimate need that we recognize that the government protects us from terrorism, we almost always must ensure that Americans' rights to their due process and their day in court are always protected. You need to be guaranteed that your government is looking out for your rights. Upon our founding, every American was guaranteed fundamental God-given rights that cannot be taken away from the government. These amendments ensure that these rights are safeguarded. I yield my time to the gentleman from Arizona for such time as he may consume.
Gentleman recognized.
Thank you, Mr. Speaker. This little document here, the Constitution of the United States, is something that we all cherish, something when we were all sworn in, we raised our right arm to the square and we said that we would uphold this document. It is the framework this nation is built upon. And there are certain inalienable rights that are created in that document that we just can't wave away. Some of those rights, I think, are embedded in, or concerns about these rights are embedded in this bill. I have real concerns about American citizens being detained for an unspecified amount of time. I believe that this amendment goes a long way toward shedding the light, the light of transparency on how these American citizens are handled. And I think that's the very least that we can do as a body to make sure that our people's fundamental rights of freedom are protected. One of the great leaders and founding fathers of this nation, Benjamin Franklin, once said, "Those who are willing to trade their freedom for security deserve neither and shall probably lose both." I yield back to Mr. Radel.
Gentleman reserve the balance of his time.
Yes, Mr. Chair, I yield back the balance of my time.
Yield or reserve?
No, I'm done. I yield back, sir.
Gentleman yields back his time. Gentleman from Washington.
Parliamentary inquiry, this has happened a couple of times. Isn't it the normal order that one person speaks and then they reserve and then the opposition speaks? A couple of times they've just moved on to their next speaker and gone through, and as I understand it, parliamentary, that is not the way it's supposed to happen.
That's normally, but recognition was within the discretion of the chair.
That's with the discretion of the chair.
Gentleman.
Let him go. Okay, that's fine. I rise to claim the time in opposition, even though I'm not in opposition to the amendment.
Without objection.
Thank you. I appreciate the opportunity to speak on this. I think it's very straightforward. Certainly we should acknowledge and have this bit of information made available to us, and I don't oppose that. I just want to take the time to raise the issue of the next amendment, the Smith-Gibson amendment that's coming up, and on this whole broader issue. And this is a very simple, straightforward debate, and that is the militarization of U.S. law enforcement. And that's really what we're concerned about with indefinite detention. And there are some who believe that any terrorist act committed within the U.S., that the U.S. military should basically take over. You should have indefinite detention. You should basically get rid of the normal due process contained in the Constitution. I think that is dangerous, wrong, and wholly unnecessary. I think the U.S. Constitution and the Department of Justice have proven themselves more than capable of investigating, capturing, prosecuting, trying, convicting, and incarcerating all the terrorists in the U.S., and I think it is a dangerous step towards executive and military power to allow things like indefinite detention under military control within the U.S. That's the heart and the essence of this issue. You know, we're dancing around the U.S. citizen question. I take Mr. Goodlatte at his word. I believe that the Constitution doesn't apply to everybody, but it doesn't just apply to U.S. citizens either, as he acknowledged. It applies to U.S. persons, broadly speaking, people who have a connection to this country. We shouldn't just protect U.S. citizens. We should protect U.S. persons under that constitutional definition. In a very straightforward way, do you believe the President of the United States should have the power to indefinitely detain people captured within the U.S. without the normal due process of law? I don't. And honestly, I don't think most Americans do. And I don't think most members of Congress do. We've gotten bogged down in different little sub-pieces of the debate in U.S. citizens and who counts and who doesn't count. But the fundamental question is, do you believe that the President should have the power to indefinitely detain people captured in the U.S. without normal due process of law? If you don't, if you are concerned about that executive power, then the only way to take that out of our law is to vote for Smith-Gibson. The rest of this just sort of moves it around on the edges, but very clearly leaves that power with the President, a power I don't think that he should have. With that, I yield back the balance of my time.
Gentleman yields back the balance of his time. The question is on the amendment offered by the gentleman from Florida. All those in favor say aye. Aye. All those opposed, no. In the opinion of the chair, the ayes have it. The ayes have it, and the amendment is agreed to. It is now in order to consider amendment number 13, printed in Part B of House Report 113-108. For what purpose does the gentleman from Washington seek recognition?
Amendment.
Clerk will designate the amendment.
Amendment number 13, printed in Part B of House Report number 113-108, offered by Mr. Smith of Washington.
Pursuant to House Resolution 260, the gentleman from Washington, Mr. Smith, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from Washington.
Thank you, Mr. Chairman. I yield 1.5 minutes to the gentleman from New York, Mr. Nabler.
The gentleman is recognized for 1.5 minutes.
Thank you, Mr. Speaker, and thank the gentleman for yielding. I rise in strong support of the Smith-Gibson amendment. When we consider the fiscal year 2012 version of this bill, I argued in opposition to sections 1021 and 1022. I argued then, and I still believe now, that these provisions go far beyond the AUMF to suggest that the President has the authority to detain even U.S. citizens without charge indefinitely. The AUMF gives the President no such authority. Clearly, we must roll back these provisions. The Smith-Gibson Amendment prohibits the detention without charge of any person arrested or detained in the United States and is the first step towards restoring due process of law. It is a good first step, but its scope is limited to U.S. soil and to the present AUMF. We should do more. That's why I've introduced the No Detention Without Charge Act, which would apply to all persons in U.S. custody at home and overseas, and to all authorizations to use military force, present and future. It not only prohibits detention without charge of people arrested in the United States, but also prohibits the detention of any person anywhere, except to the extent permitted by the Constitution and the law of war, and restores a meaningful right of action for detainees to challenge the legality of their detention. The notion that the United States ought to conduct itself according to the Constitution and the law of war should not be controversial. Smith-Gibson takes the first step towards and I have proposed the next, towards affirming our values and securing our liberty. We should not. This clarifies that the AUMF does not give any president the authority to detain people without due process of law and to detain them indefinitely. I urge my colleagues to support this amendment and to sign on as co-sponsors of my bill, but right now support the Smith-Gibson Amendment. I yield back.
Gentleman from California.
Mr. Chairman, I rise to claim the time in opposition to the
Gentleman's
amendment.
recognized for 5 minutes.
Mr. Chairman, I yield 2 minutes to my friend and colleague, the gentleman from Texas, Chairman of the Homeland Security Committee, Mr. McCall.
Gentleman's recognized for 2 minutes.
Thank you, Mr. Chairman. I thank the gentleman from California. My fellow chairman, I rise in opposition to this amendment. As the terrorist attacks in Benghazi and Boston demonstrate, our fight against those who mean us harm and those who inspire is far from over. This amendment is of questionable constitutional standing, as it seeks to deprive any president of lawful options that he needs to protect America, hinders our ability to gather information, and actually provides an incentive for terrorists to come here to attack us. It prohibits the president from ever detaining anyone in the United States, including a foreign terrorist, under the authority of the 2001 Authorization for Use of Military Force. This amendment requires that foreign terrorists could only be prosecuted in civilian courts. But what if they could not be successfully prosecuted? Currently, there are detainees in Guantanamo who are too dangerous to release but are not prosecutable. Under this amendment, if similarly situated terrorists were captured here at home, they would have to be released. Our experience trying to deport illegal aliens whose native lands refuse to accept their return demonstrates the untenable position this amendment will leave us in. If we can't use the AUMF to hold detainees and we can't successfully prosecute them in a civilian court, then what can we do? The amendment ignores the reality of the threats that we face every day. Consistent with the laws of war, we have long recognized the authority to detain enemy combatants for the duration of hostilities. In 2004 Hamdi decision, the Supreme Court reaffirmed the authority to detain a U.S. citizen captured fighting with the Taliban, who was later detained in the United States, and that such detainees have the right to challenge their detention. And in 2012, the NDA reaffirmed the detention authority provided by the 2001 AUMF, as well as a right to habeas corpus determinations. The amendment overturns established legal precedent, as well as undermines the statutory support for the AMUF. It does not make us safer. It increases our peril, and I urge my colleagues to vote against it.
Washington.
Chairman, I yield 1.5 minutes to the gentleman from New York, Mr. Gibson.
Gentleman is recognized for 1.5 minutes.
Thanks, Mr. Chairman, and I thank the gentleman from Washington. I'm honored to be offering this amendment with him. And from our Bill of Rights, the Fifth Amendment, no person shall be deprived of life, liberty, or property without due process. And from our Sixth Amendment, the accused shall enjoy the right to a speedy and public trial. That is the supreme law of the land. Evidently, we have some ambiguity based out of the 2001 AUMF, so clearly we need to offer this amendment here today, and I rise in strong support of it. When we think about the founding and that period, shortly after the Revolution, and remembering the fact that we had Americans that, at the time, that did not support the Revolution, and there were a lot of hard feelings in the immediate aftermath of the war. But one thing that united everyone was the way that we arrayed our institutions to check absolute power and further to check power, the federalism between the federal and the state governments, and of course, underpinning all of that, the Bill of Rights. The Bill of Rights that unite all of us. United us then, unite us now. And that's why I think it's very important that we bring this clarity to this matter, that we pass Smith-Gibson, and we ensure that we bring clarity to the situation, that our Bill of Rights are the supreme law of the land. And with that, I yield back.
Gentleman from California.
Mr. Chairman, I yield 1 minute to my friend and colleague, the gentleman from Arkansas, Mr. Cotton.
Gentleman's recognized for 1 minute.
Thank you. When I was a child, I played a game called hide and seek, as I suspect many of you might have played. There was a phrase in that game called "Ollie, Ollie, Oxenfree." Meant you could come out. You were safe. You no longer had to hide. This amendment is the "Ollie, Ollie, Oxenfree" amendment of the War on Terrorism. It invites al-Qaeda and associated forces to send terrorists to the United States and to recruit terrorists on U.S. soil. Think about what happens if you're detained in the U.S. for committing an act of terrorism. You will not be detained while you're interrogated. You cannot be used to stop future attacks. Think about what will happen. You will get your Miranda warnings. You will get an attorney at taxpayer expense. And you will, if acquitted and not accepted by your home country, be released into the streets of the United States. We are encouraging al-Qaeda to send terrorists here if we adopt this amendment. Consider also about an illegal alien crossing our border. If he does so to get a job, Customs and Border Patrol can detain him and summarily deport him. If he's detained by intelligence or military professionals, what happens? He goes into the court system and he gets all the rights due to a common burglar. The concerns that we have about due process are misplaced. The law plainly lets every person, a citizen or foreigner, file a petition for the writ of habeas corpus to challenge their detention. I strongly oppose this amendment.
Gentleman from Washington.
Thank you, Mr. Chairman. I yield 1.5 minutes to the gentleman from Michigan, Mr. Ramash.
Gentleman from Michigan is recognized for 1.5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Speaker. In 2011, Congress enacted a provision of the NDAA that authorizes the indefinite detention of Americans caught on U.S. soil. That provision, which is permanent law and continues to apply to this day, authorizes the President to detain persons who substantially supported forces associated with terrorists. It's important to note that substantial support and being associated with terrorists were not defined in 2011 and still have not been defined by Congress. There's a good argument that this provision is unconstitutionally vague. In fact, a federal court has already ruled that the provision is unconstitutional because it chills First Amendment association and free speech. Our Constitution does not permit the federal government to detain anyone in the United States indefinitely without charge or trial. I strongly believe in protecting the country's security and equipping our armed forces with the tools they need to defeat our enemies. But the American people cannot support measures that, in the name of security, violate our constitutionally protected rights. The Constitution entitles all people to be charged with a crime and given a trial when the government detains them in the United States. Join me in affirming this right by voting for Smith-Gibson, which is the only amendment that protects the rights of those of you watching at home. I yield back.
Gentleman from California.
Mr. Chairman, I yield 2 minutes to my friend and colleague, the gentleman from New York, Mr. King.
Gentleman is recognized for 2 minutes.
I thank my good friend, the chairman, for yielding, and I rise in opposition to the Smith-Gibson amendment. Having said that, let me express my deepest respect for the ranking member, Mr. Smith, and my colleague from New York, Mr. Gibson, who has served his nation long and well, and certainly acts within the very best of intentions, and I certainly admire his patriotism and dedication. Having said that, I strongly identify with the remarks of Chairman McCall and Congressman Cotton. And I think the ultimate theory here, or the ultimate fact here, is that we would be giving terrorists more rights if they come to the United States than if they've been captured overseas. And to say that everyone captured in the United States is entitled to the full rights of a citizen or a person lawfully in this country takes away from the fact if a Nazi soldier had attacked the United States during World War II, would he have been entitled to all the rights of a citizen? In fact, the Supreme Court ruled on that. We had Nazi saboteurs land in New York. during World War II. They were arrested, tried before a military commission, and executed with the approval of the United States Supreme Court. In the Hamdi decision, it specifically said just several years ago, the plurality of the court said, there is no bar to this nation's holding one of its own citizens as an enemy combatant. A citizen, no less than an alien, can be part of supporting forces hostile to the United States or coalition partners and engage in an armed conflict against the United States. The fact is, we should not be saying there's an incentive for a terrorist to come from Afghanistan and come to the United States to fight, because if he's captured here, he gets more rights than if he's captured in Afghanistan. This is just, it goes against, to me, common sense, and it in no way is what's happening under the AUMF in any way a violation of the Constitution. So again, I just urge, as well-intentioned as this amendment is, I urge that it be defeated.
Would the gentleman yield?
I yield back my time.
Gentleman yields back. Gentleman from Washington has 45 seconds remaining.
Thank you. I yield myself the balance of the time. There is no incentive for U.S. terrorists to come here. They are trying to attack us, but we capture them successfully, try them, and prosecute them. Abdul Muttalib came here. He was captured. Yes, he was Mirandized, and even after he was Mirandized, he gave out an enormous amount of information that was very, very helpful. We convicted him. What this is essentially saying is we don't trust the Department of Justice to do their job, so therefore we have to give the President the power to detain someone whether they have any evidence of a crime or not. If they come here, the Department of Justice does its job. We have tried and convicted over 400 terrorists in this country successfully. The only incentive to come here is if they're not going to commit a crime. All of the inmates down at Guantanamo were not captured in the U.S. No one who's been captured in the U.S. as a terrorist have we failed to convict. Let's trust the Constitution. The Constitution doesn't threaten us. The Constitution protects us. Let us use it, and use it to bring these terrorists to justice, as every single time we have successfully done. I urge support for the amendment.
Question is on the amendment offered by the gentleman from Washington. All those in favor say aye. Aye. All those opposed, no. Opinion of the Chair, the noes have it.
Mr. Chairman?
Gentleman from Washington.
I ask for a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Washington will be postponed. For what purpose does the gentleman from California seek recognition?
Mr. Chairman, pursuant to H.Res. 260, I offer amendments en bloc.
Clerk will designate the amendments en bloc.
On block number 2, consisting of amendments numbered 27, 31, 38, 43, 44, 45, 46, 47, 49, 54, 81, 84, 85, 95, 96, 97, 114, 143, 164, and 165. Printed in House Report number 113-108, offered by Mr. McKeon of California.
Pursuant to House Resolution 260, the gentleman from California, Mr. McKeon, and the gentleman from Washington, Mr. Smith, each will control 10 minutes. The Chair recognizes the gentleman from California.
Mr. Chairman, I yield 1 minute to my friend and colleague, the gentlelady from Minnesota, Ms. Bachmann.
Gentlelady is recognized for 1 minute.
Thank you, Mr. Speaker. I rise today in support of this amendment package, which includes 3 amendments which I've authored to protect and honor America's brave men and women in uniform. The first and the second amendments would both properly train and equip and staff the Marine Embassy Security Group and the Crisis Response Task Force. In the wake of Benghazi and the tragedy there, protecting our nation's embassy personnel and classified materials has never been more important. The third amendment requires certain federal buildings that are already required to fly the POW MIA flags on federal holidays to fly those flags every day. We owe it to the memory of those who serve to honor their commitment and give them the funding and support that they need. And I urge my colleagues to support this package. I want to thank you to Mr. McKeon, and I yield back.
Gentleman from Washington.
Chairman, I yield 4 minutes to the gentlelady from Texas, Ms. Jackson Lee.
Gentlelady from Texas is recognized for 4 minutes. Without objection. Gentlelady is recognized for 4 minutes.
Let me thank the gentleman from Washington for his leadership and the gentleman from California for their work with my office and staff One of the efforts that we have been working on, when I say that Congress, individual members, is to approach and to continue to work on the issue of breast cancer that impacts women throughout this country, and certainly women and men in the United States military. I'm very pleased in this en bloc to have an amendment by Jackson Lee that really cements the collaboration between the Department of Defense, Office of Health, to collaborate with the National Institutes of Health to provide resources to identify specific genetic and molecular targets and biomarkers for triple-negative breast cancer, often not heard of. But I will tell you, in the course of my involvement, I've had daughters of those who lost their lives. Triple-negative breast cancer is a particularly negative but deadly form of breast cancer where the victim does not last very long. I've lost dear friends, and this highlighting the biomarker will bring down the cost of treatment, but more importantly will help to stem the tide of those who quickly die because there is no treatment, because it accelerates so quickly and lives are lost. I also am grateful that we are beginning to make some steps. So I indicated my support for the Spears and Gabbard amendment. I am pleased to be able to have in this language a place, a board, a place where sexual assault prevention information and resources, bring it out of the open. Let people know, men and women, of how they can access resources. Let's put it forward so that people are safe, so that we can stop it, get in the gap. And I think in honoring our men and women in the United States military and our women, it is particularly important. Over the years, I have supported increased funding for PTSD and recognized the crisis that many of our soldiers are facing in the need of mental health services. We can see some of the impact of those in terms of family situations and violence, domestic violence, and so I have in this en bloc an amendment that will provide more mental health counselors or focus on more mental health counselors to ensure that the 200,000 veterans of military service and active duty soldiers will have the ability to be able to get that kind of service. It is also important to be fiscally responsible, and I have an amendment that improves the management of defense equipment and supplies through automated information data capture technologies. This would support the work of the DoD to adopt a proven private sector method for more efficiently managing inventory, and that's inventory going from what we have in Afghanistan to leftover in Iraq to many other places. We want to save money. I also am very grateful that there is a managers that in this en bloc, something very close and near and dear to my heart, and that is the outreach to the Department of Defense, by the Department of Defense, to small businesses, minority-owned businesses, women-owned businesses. I can tell you that they are the backbone of America, but in working, even though we're downsizing on some of the contractual relationships, even though we're downsizing, I can tell you that obviously they bring about $537 billion that is obligated by federal agencies. These small businesses can benefit. They create jobs, and the outreach is going to be vital beyond where the bases are, beyond where the areas where you would likely think. Let me also say this. I want to thank the committee for working with me on an amendment that I thought was very important, and that is to study the procurement practices of our intelligence assets and to be able to improve how we deal with intelligence. I know that we will work together on that going forward, and I believe that it is important that we do work together. These are amendments that I believe will improve the conditions of our very important military personnel, and again, to all of them, happy Father's Day. I yield back.
Gentleman from California.
Mr. Chairman, I yield 2 minutes to the gentleman from Alaska for the purpose of a colloquy.
Gentleman's recognized.
I thank the gentleman for yielding. I rise to thank my good friend and chairman of the Armed Services Committee for including an amendment on Section 811 of the fiscal year 2010 National Defense Authorization Act in one of today's en-bloc packages, and ask if he's concerned, as I am, that the implementation of the federal agencies of Section 811 FY10 National Defense Authorization Act has been inconsistent and contrary to the congressional intent. Will the gentleman
yield?
Yes, I gladly yield to the gentleman.
I thank the gentleman from Alaska for raising concern over inconsistency in implementation of Section 811. to our attention.
I thank the gentleman. I ask the distinguished chairman of the Armed Services Committee if he agrees with me that Section 811 was not intended to be a cap or a bar on sole source awards above $20 million, and also ask if he's concerned about the growing number of reports that agencies are treating the threshold requiring sole source justification as a prohibition on such awards.
Will the gentleman yield?
I yield to the gentleman.
I agree that Section 811 was intended to provide increased oversight of sole source contract awards, but was not intended to be a prohibition on such contracts.
Mr. Chairman, I ask you to join me with my colleague from Hawaii, Ms. Hanaboso, to continue oversight on federal agency implications of Section 811 and is requesting the Comptroller General will provide us with a full report into respect of any inconsistencies in the ways agencies are implementing Section 811 and negative impacts on such sections as having Native American contractors and provide recommendations on how the provision should be better implemented. Such a report will aid Congress in ensuring that Section 811 is implemented so that it makes clear that the provision does not impose a cap or limit on awards covered by the provision, so long as the justifications and approval is attained pursuant to the provision, that the provision is intended to provide a level of oversight and approval, not act as a prohibition or limit upon rewards.
I will be happy to work with the gentleman and with our colleague from Hawaii to send a joint letter to the Comptroller General in the manner he suggests and to consider oversight on this issue. I reserve the balance of my time.
Gentleman reserves the balance of his time. Gentleman from Washington.
Thank you. I yield 2 minutes to the gentlelady from California, Ms. Hahn.
Gentlelady from California is recognized for 2 minutes.
Thank you, Mr. Chairman. Mr. Speaker, I rise to speak in support of Amendment 246, which is a bipartisan amendment that I co-sponsored with my good friend, colleague, Congressman Don Young. You know, despite the vital role that they play to our economic strength and national security, our ports, unlike nearly every other mode of transportation, still do not have a dedicated source of federal funding for infrastructure projects. Ensuring that our ports have the infrastructure funding they need is not only critical to strengthening our economy, but also to making sure that our ports can handle the sudden needs of rapid deployment in the outbreak of war or during a national emergency. This amendment would allow the Maritime Administration to provide infrastructure grants to our nation's ports and prioritize funding for our strategic seaports. By finally giving MARAD the tools that they need to successfully mitigate congestion and increase the flow of goods at U.S. ports, we will ensure our ports will be fully prepared to serve our national defense and continue to be the strong economic engine that drives our nation's prosperity. I want to thank Congressman Young for working with me on this amendment, as well as my colleague from California, Chairman McKeon, and Ranking Member Smith for accepting this amendment en bloc. I yield back the balance of my time.
Gentleman from California.
Mr. Chairman, I yield 1 minute to my friend and colleague, the gentleman from Alaska, Mr. Young.
For 1 minute.
I thank the Chairman, including my amendment in this package. My amendment is very simple. It asks the Department of Defense to report on what actually makes an installation in the Pacific strategically important. In my many meetings with military leaders, I'm always told that the strategic importance of various installations in Alaska and all across this country. However, strategic is never fully defined. My amendment merely asks the Department of Defense to qualify and quantify exactly what makes the installation strategic. As every Alaskan knows, Alaska has numerous strategic installations that proudly protect this country from harm. Among these are bases are Eielson Air Force Base in Fairbanks, as the home of the 18th Aggressor Squadron. This squadron provides our nation pilots with real-life training they need to be best in the world. Throughout the year, but especially during Red Flag Alaska, the F-16 aggressors fight realistic mock battles in the largest training range in the United States. It's one of the most terrain-diverse training areas of the world. Eielson Air Force Base is also home to the strategically important 168th Air Guard Refueling Wing. These KC-135s provide the long leads for our nation's northern air bridge that allows us to protect and project power into the Arctic and into the northern Pacific. I have confidence that my amendment and the following DOD report will show that General Billy Mitchell recognized in 1935, namely Alaska is the most strategic place in the world. Thank you, and I yield back the balance of my time.
Gentleman from Washington.
Thank you. I yield 2 minutes to the gentlelady from Hawaii, Ms. Hanabusa.
Gentlelady from Hawaii is recognized for 2 minutes.
Thank you, Mr. Speaker. I rise to speak in support of en bloc amendment number 244, the Young Hanabusa Amendment. Section 811 of the fiscal year 2010 NDAA required that any 8A Native American sole source contract in excess of $20 million go through a heightened justification and approval. The justification and approval is often interpreted to be approved by the head of an agency, and this requirement is shown by a recent GAO report to cause a 60% decline in revenue from these contracts. It has resulted in a loss of jobs, reduced benefits to Native Americans, and has led to a large amount of unintended discriminations against Native community-owned firms. What the amendment does is it makes it a delegable authority. In my home state of Hawaii, there are numerous 8A enterprises known as Native Hawaiian organizations. These entities are conducting critical research for our defense industry and other sectors of government, while also supporting critical programs within the community. It makes no sense to place onerous requirements on these successful organizations that significantly decrease the ability to conduct business. Further, I support the letter to the GAO requesting a full and detailed report with respect to any inconsistencies in the way the agencies are implementing Section 811, the negative impacts such section is having on Native American contractors, along with recommendations of how the provision should be implemented. Mr. Speaker, I also would like to thank the Chairman, the Ranking Member, and my colleague Mr. Young from Alaska for this amendment and for placing it in the en bloc package. And I yield back.
Gentleman from California.
Mr. Chairman, I yield 1 minute to my friend and colleague, the gentleman from Colorado, Mr. Lamborn.
Gentleman from Colorado is recognized for 1 minute.
Thank you, and thank you, Mr. Chairman. I rise today to highlight my amendment number 143, which expresses the sense of Congress highlighting the threat posed by Hezbollah. Hezbollah is one of the world's most dangerous terrorist organizations. After al-Qaeda, it is responsible for the most deaths of American citizens. Hezbollah is behind a series of terrorist attacks around the world, including the foiled plot to assassinate the Saudi ambassador here in Washington. Hezbollah is backed by the Iranian regime and has now joined the fight to protect another Iranian proxy, the Assad regime in Syria. Hezbollah was behind an attack last summer in Bulgaria that killed 5 people. Unfortunately, the European Union has not yet listed Hezbollah as a terrorist organization. My amendment calls on the EU to recognize that Hezbollah is a terrorist organization. Please vote yes on this amendment to stand against terrorism. Thank you, Mr. Chairman, and I yield back.
Gentleman from Washington.
Thank you, Mr. Chairman. I yield back balance of my time.
Gentleman yields back the balance of his time. Gentleman from California.
Chairman, we have no further speakers. I urge adoption of the en bloc amendment and yield back the balance of my time.
Gentleman yields back the balance of his time. The question is on the amendments en bloc offered by the gentleman from California. Those in favor say aye. Aye. Those opposed, no. In the opinion of the Chair, the ayes have it. En bloc amendments are agreed to. Pursuant to Clause 6 of Rule 18, proceedings will now resume on those amendments printed in Part B of House Report 113-108, on which further proceedings were postponed in the following order. Amendment number 2 by Mr. Blumenauer of Oregon, Amendment number 3 by Ms. Loomis of Wyoming, Amendment number 5 by Mr. Kaufman of Colorado, Amendment number 9 by Mr. Riggle of Virginia, Amendment number 10 by Mr. McGovern of Massachusetts, Amendment number 11 by Mr. Goodlatte of Virginia, Amendment number 12 by Mr. Smith of Washington. The Chair will reduce to 2 minutes the time for any electronic vote after the first vote in this series. Oh, sorry. The unfinished business is the request for a record vote on Amendment number 2, printed in Part B of House Report 113-108 by the gentleman from Oregon, Mr. Blumenauer, on which further proceedings were postponed and on which the noes prevail by voice vote. The clerk will redesignate the amendment.
Amendment number 2, printed in Part B of House Report number 113-108, offered by Mr. Blumenauer of Oregon.
A recorded vote has been requested. Those in support of the request for a recorded vote will rise and be counted. Sufficient number having arisen, a recorded vote is ordered. Members will record their votes by electronic device. This will be a 15-minute vote.
The House has been debating amendments to the fiscal year 2014 Defense Authorization Bill, authorizing $552 billion in defense spending and $86 billion for the war in Afghanistan and other overseas operations. Some 172 amendments allowed under the rule for the bill, and votes on 7 of them here. This one by Earl Blumenauer of Oregon, which would reduce from 11 to 10 the statutory requirement for the number of operational aircraft carriers that the Navy must maintain. On other defense issues, the Associated Press is reporting this afternoon that U.S. officials say the Obama administration has concluded that Syrian President Bashar Assad's regime has used chemical weapons against the opposition, seeking to overthrow him, crossing what President Obama has called, quote, a red line. On the Senate floor just a short while ago, Senator John McCain of Arizona saying that the White House will announce support for the rebels. Senator McCain on the floor now with Senator Lindsey Graham talking about Syria. You can follow their comments on our companion network, C-SPAN 2. Here on C-SPAN, the first of 7 amendment votes, and for some details on this defense authorization bill, we spoke to a Capitol Hill reporter. Covering the House debate is John Bennett, senior congressional correspondent for Defense News. What are some of the key amendments you're watching?
What we're going to see is the House work through over 170 amendments. That's more than last year. House aides tell me that they think they can wrap up on Friday. We'll see how late they stay and what they can get done. But we're going to see amendments on everything from the size of the defense budget to Afghanistan policy, drone policy. We should see a couple amendments calling for shifting the drone program from the CIA entirely to the military. And we're going to see a couple of Iran amendments as well. And you'll get other things, some weapon programs amendments, but the weapons amendments will be, I think, more just tinkering around the edges. There's certainly, members are not going to call for canceling programs as part of this process.
On Afghanistan, what does the bill say about the war in Afghanistan and the drawdown of operations in Iraq?
Well, it doesn't say much about Iraq. That is pretty much U.S. policy there is the Iraq war is over, and that's more of a diplomatic effort at this point for the most part. On Afghanistan, we're going to see some amendments. We should see some amendments that would call for the ending of the war immediately. These are Democratic amendments. There's some bipartisan amendments that would call for wrapping up the Afghanistan war faster than President Obama wants to. That's the end of 2014 is his date. But those amendments, they're mostly Democratic amendments, and they just don't have the votes to pass, it looks like.
In the Rules Committee, the Democrats were denied a couple of amendments dealing with sexual assaults in the military. What would those amendments have done, and why were they denied by the Rules Committee?
Those amendments would have taken immediate commanders out of the decision process for whether alleged perpetrators of sexual assault if charges were brought up. And the Rules Committee, the Republican Rules Committee, sided with Defense Secretary Chuck Hagel and Senate Armed Services Committee Chairman Carl Levin. And what Hagel and Levin have decided is taking the commanders out of the decision process would actually make the current process worse. They feel commanders should be directly responsible and make the decision on whether charges are brought. They say it would hurt unit cohesion, and it would actually undermine the commander's authority within their own units. As a side note, what Levin and folks in the House who agree with him, they're going to put more pressure on commanders to change the culture of the military. So they oppose these amendments because they think the commanders are actually central to correcting the problem of military sexual assaults.
The bill authorizes $52 billion in spending above the sequestration levels. How do supporters of the bill justify that?
Well, supporters of the bill, they point to the President's own budget request, the Pentagon budget request, and his broader federal budget request, which also does not account for sequestration. They're budgeting to the House budget resolution from Chairman Paul Ryan, and what everyone's doing here is putting forth plans that could be enacted if a grand bargain is passed sometime this year, And of course, a grand bargain would address sequestration. It would significantly lessen the defense cuts, or it would replace those with other deficit reduction measures. So everyone is gambling here that a grand bargain will come together in the late summer or the early fall.
So what's the administration said about the spending levels, and more broadly, what do they think about the bill?
The White House has said it would veto the bill at the current level of DoD funds that it would authorize. They want the bill to be brought down, whatever eventual authorization bill that goes to the President's desk. They want it at levels that were set in the same law, the same August 2011 law that created sequestration. The Budget Control Act has defense spending caps, domestic spending caps, and the White House has said that Congress, as they work through putting together a final defense authorization bill, needs to bring it down under those caps.
And where's the Senate with their defense authorization bill?
The Senate Armed Services Committee is still marking up their bill. It's unclear when that would come to the Senate floor, but by the end of the week they should be finished with their version of this bill.
John Bennett is senior congressional correspondent with Defense News. An update. We appreciate you being with us.
Thank you.
And this is the first of 7 amendments to get recorded votes on the defense authorization bill. An amendment by Earl Blumenauer of Oregon, which would reduce from 11 to 10 the statutory requirement for the number of operational aircraft carriers the Navy must maintain. This is a 15-minute vote. On Syria, the White House announcing this afternoon they now believe that the Syrian regime of Bashar Assad did use chemical weapons against the Syrian people. Ben Rhodes, Deputy National Security Advisor, releasing a statement this afternoon saying, "Our intelligence community has high confidence that assessment given multiple independent streams of information. The intelligence community estimates that 100 to 150 people have died from detected chemical weapon attacks in Syria to date." That's a statement just released from the White House. Earlier today on Capitol Hill, an event marking the 6-month anniversary of the school shootings in Newtown, Connecticut, a group of lawmakers and victims' families gathered on Capitol Hill to renew their call for gun control legislation. We'll start with remarks from Senate Majority Leader Harry Reid, show you as much as we can during this 15-minute vote.
The work that you're doing on this issue is very, very important. Sometimes people have very, very short memories. Prior to coming here, my last meeting was with a group of people who are working nationally to prevent suicide. Had a mother and a father there from Nevada with the others who had lost their son to suicide, 21-year-old young man. The reason I mention that to you is that those of us who experience suicide in our lives understand how important it is to remember. My dad killed himself with a pistol. He was a relatively young man, especially as I get older. His age doesn't look so old. We have to remember what took place in Connecticut, that little elementary school, and can never take those names out of our minds. 26 little boys and girls and 6 educators. Your responsibility is to make sure that the American people do not forget what happened there. I mean, I could see the tears out here as the names are being read. And I'm here to tell you, with the other members of Congress that are behind me, that we're not going to give up the fight. When Republicans voted against this legislation on the Senate floor, they voted against 90% of the American people. The fight is not over. It's just beginning. I'm hard-pressed to find another issue where 90% of the American people think it's the right thing to do. This is the issue. 90% of the American people feel that someone who has mental problems, severe mental problems, and is a criminal shouldn't be able to buy a gun. No wonder 90% of the people think this is the case. But I want everyone here to understand the writing is on the wall. The Republicans who voted against this, the writing is on the wall. And the Democrats have voted against this, the handful of them that voted against this. In the Senate, 90% of the Democratic senators agreed with 90% of the American people. The Republicans didn't even get 10%. The writing is on the wall. Background checks will pass the United States Senate. It's only a question of when. I want to be very, very clear, though. In order to be effective, the bill that passed the Senate must include background checks and not a watered-down version of background checks. We're not going to let the forces of an extreme minority water down and damage the content of this bill. The forces against this bill cannot hold out forever. And we're close. There are conversations going on. They haven't borne much fruit yet, but they will, because they cannot stand in the way of 90% of the American people. So I say to each of you today, don't give up. We're not going to give up, those behind me. The fight is right, and it's one we're going to win. And I'll never forget the 26 deaths. But sadly, there have been thousands of others since then. But you are the key to our getting something done, because the American people identify with what happened in that little elementary school in Connecticut. It's my pleasure now to introduce, and you know, I know we in Congress throw this around, you know, my friend, but I am going to introduce my friend. We're forever friends. Someone who has stood shoulder to shoulder with me and people who want to get something done in this country. I've had the good fortune to serve with a number of speakers. Well, I've served more than 30 years in the Congress, and I'm a student of history. As far as I'm concerned, we've never, ever had a better speaker than Nancy Pelosi.
Thank you very much, Mr. Leader. Thank you, Mr. Leader, for your generous introduction, but really, more importantly, for your very strong words of commitment to making sure that we honor our oath of office to protect and defend the American people and our Constitution. Your strong words, your determination are ones that we in the House, and the leadership of Congressman Mike Thompson, of Congresswoman Elizabeth Esty, in whose district the Newtown tragedy occurred, and my colleagues, other colleagues who are here and those from the Senate whom you will be hearing from, know that what you said is music to our ears. Very, very sad music, that this should be necessary. It is really a humbling experience to be here with some of the families of Newtown, the Soto family, and how eloquently and beautifully they spoke about the tragedy and the determination to go forward. To be here with the father of Lauren Rousseau. Her mother gave me her picture yesterday, and on it says, "In her memory, please be a persuasive voice for peace on earth." That peace on earth has to begin with us, in our hearts and in our communities. And so I thank the families of Newtown for turning your grief into action. The grief is still there, but the action is essential. Your unimaginable loss, turning that into unsurpassed determination to carry on. Yesterday, many of the families of Newtown met with Democratic and Republican leaders, but their agenda was nonpartisan. We had an opportunity to hear their commitment to the cause, and as Leader Reid has said, we're not backing down. This is not over. In many ways, we've begun another phase in this fight. Today, by reading the names of 5,000 victims of gun violence since the Newtown tragedy, by forming a human ribbon of remembrance, these families and their supporters are sending a clear message. Let's honor the members of every victim by ensuring that no other family is forced to endure such a terrible tragedy. For 6 months, we've talked about a response to Newtown.
tomorrow being the 6-month anniversary. Now we must act upon our promises. We must take inspiration from the families. We must heed the moving words of the Sandy Hook promise. Our hearts are broken. Our spirit is not. We must hold our most basic responsibility as members of Congress to protect and defend. We must pass legislation in the House and in the Senate for gun violence prevention, most notably now in the form of the background checks. It's something that will have a tremendous effect on safety. To protect and defend, that is what the Newtown families are asking of us. That's what we must do in Congress. And that is why I am pleased to present to you a champion for this cause, Senator Blumenthal of Connecticut. Thank you.
Thank you. Thank you, Speaker Pelosi, and thank you for your leadership over many, many years on this issue. Thank you to Harry Reid, who has been an unshakable champion for this cause. And I've been with him over these past months and years, and not only is his mind, but his heart is in this cause. And thank you most importantly to the families of Newtown and the community who have relived their grief, that unspeakable sadness, and made this cause their mission. They have come here and demonstrated through the power of their courage and strength what it means to speak truth to power. And I just want to urge all of my colleagues in Congress, and most especially in the Senate, to please agree to meet with the Newtown families. Some of them have closed their doors or turned their backs. Listening to them today in this forum, how could they refuse to hear out and meet with the Newtown families and community? I urge them to do so. The December 14th tragedy transformed America. It put us on an unstoppable trajectory toward gun violence prevention. There's a lot of talk these days about losing momentum, diminishing passion. We're here to say the momentum is undiminished. The passion is stronger, if anything. We lost the first vote, but we're going to win the last vote. And the one who wins the last vote is the one who wins. And I can guarantee we'll have another vote, and I believe that we will win it. We don't need converts among the American people. We need converts in the Congress. We need activists among the American people. The continuing mobilization and organization that your groups are doing will turn the tide and carry the day, because they will convert our colleagues who still have doubts or reservations. And we will overcome those doubts and reservations. Those conversations are ongoing right now. There's no need to transform this bill to achieve background checks and transform America, make it safer. And I believe that we are within grasp, just a handful of votes, and we're moving forward in that effort. December 14th was a day of searing sadness, but April 17th was a day of shame. And you have heard here what I believe the American people feel. Inaction is unacceptable. Inaction is unacceptable not only because of the 26 beautiful lives that were lost on that day, but also because of the almost 5,000 who have perished since then. They may not have been in the headlines, but the sadness for their families and loved ones and friends and neighbors is as palpable and important as it is for anyone. And so I think today we should make no mistake. We had 55 votes in April. 55 votes ordinarily is a majority. We're going to win with 60 votes. But the 55 votes reflect the 90%, and it's a bipartisan 90%. There's nothing Republican or Democrat about saving America from gun violence. That cause will be bipartisan, and it will enable us to continue to stand up and speak out. Make no mistake, the NRA and the special interests have been the schoolyard bullies here. They've ruled. 6 months ago, this issue was thought to be untouchable. Now our cause is unstoppable. We stood up to the schoolyard bullies. We're going to continue to stand up to them, and eventually we will beat them. And in part, it's because of my colleagues, Joe Courtney, Elizabeth Esty, others in our delegation who are not here today, and very importantly, my colleague, my friend and partner in this effort, Senator Chris Murphy.
Thank you very much, Senator Blumenthal. You know, it's commencement address season, and the shortest commencement address that was ever given was given by Winston Churchill, and it was this: never give up, never give up, never give up. We have a message to the NRA, to the gun lobby, to the proponents of the status quo. We are never going to give up. We are never going to rest until we have done everything within our power to make sure that another community, that another family doesn't have to go through what Newtown, what the Sotos, what the Rousseaus and the Sherlocks and the Pintos are going through today. And we are never going to give up until we have an answer to the 5,000 families across this country who have lost their loved ones to gun violence since December 14th of last year. Now, Senator Blumenthal and Senator Reid both referenced the fact that there are some encouraging but thus far fruitless discussions happening on the Senate floor to try to revive a bill that passed, but because of the Senate rules did not make it to the House of Representatives. Why is that happening? Why are we going to get a second chance on the issue of gun reform when very few other issues get a second chance on the floor of the Senate? Well, I'll give you two reasons, and then I'll pass along the microphone. One reason is standing behind us today. It is the indomitable spirit of the families of Newtown who have refused to take no for an answer. I agree with Senator Blumenthal. It is absolutely unconscionable that there are members of the Senate and members of the House who will not meet with these families. Have the guts to take a meeting. Have the courage to look these families in the eye and tell them no, personally. Because if you take the meeting, if you hear their story, and if you hear their plea, then there will be something unlocked in your heart that will get you to yes. That's the first reason why we're going to have a second chance at this. The second, though, is that there is for the first time ever a political infrastructure built around gun violence reform that never existed before. The NRA used to play in elections in a vacuum. No longer. Members who cast the wrong vote in April will bear political consequences at the ballot box next year. And it's this political infrastructure that has grown out of this tragic incident that is going to force, in part, people to do the right thing later this year. I'm so glad to be here with my former leader in the House and my present leader in the Senate. I've just been so proud every minute of my time in both chambers to be able to serve under their leadership. There's no one who has shown greater concern for the families of Newtown than they have. I'm proud, though, to introduce now someone who is with Senator Blumenthal and I that awful afternoon in Sandy Hook Firehouse, who has spiritually and symbolically never left that place, Congresswoman from Newtown, Elizabeth Esty.